Welcome back to Law News. We were listening to a clip there of the prosecutor's closing argument in the Loya case out of Barnstable, Massachusetts. The jury's had the case for about an hour now, and we are waiting to see if they come back with a quick verdict, I should say. I'm guessing they probably won't. Alan Tuerkheimer is one of our regular guests here at Law News. He's a jury consultant out of Chicago. And Alan, good to see you again, first of all. And second of all, I would hate to be a juror on this case.
Yeah, well, they certainly a couple new wrinkles with what happened at the end. There's a lot to consider. And just in general, you look at what happened, and this poor woman who was shot, was 10 or 11 times, and now they have to decide, what do we do with it? Do we send this person, or do we say, yeah, this person can maybe be rehabilitated and we're okay with that? Or do they say, no, he knew right from wrong, and then he is not guilty by reason of insanity. He knew what he was doing.
So let's take this all apart. We've first of all, just to remind everybody, jury consultants use a bit of psychology and a bit of law and roll them all together to try to get a sense of which jurors might be a little more favorable to either side in a dispute.
That's correct. So what jury consultants do is we try to figure out, all right, so who's going to really give a client or our side a fair shake, because people come in to jury duty with all kinds of biases, and not faulting individuals. Everybody has biases, and these biases are due to life experiences. They're due to certain attitudes. And so when jurors show up, just like everybody else, they're going to filter piece of information, complex evidence through their positions, their biases. And so that's why in jury selection, just find people who are biased against you or your client and strike them so they can serve on the jury.
So let's try to unpack this case a little bit here, because you've got a case with an extreme amount of pre-planning. Just strange facts, fake bombs, cars being set on fire to impede first responders, deer cameras being set up to conduct reconnaissance on the intended victim, military language involving limiting civilian casualties, a 250-page manifesto from the defendant, allegations of mental health issues. And so I look at that and say, okay, the facts are horrific and they're not really in dispute. The issue is more the mental capacity of the defendant. And how did jurors react to that? How do they try to get in that and deal with it?
Jurors don't, they're like you. They don't want to have somebody evade responsibility because of a mental disorder or a mental problem. Jurors often say that, yes, this person clearly had mental problems, but that doesn't mean that legally we're going to not hold him accountable. So juries struggle with this all the time, and it's a really hard defense to make, because if you think about it, there's a societal bias against saying, okay, well, yes, this is a horrible thing, so we're just going to let this person, give this person a very lenient verdict, so he'll be rehabilitated. And this case is interesting because I think jurors are more critical of defendants using this defense when the actions are violent in nature. So it's one thing if somebody says, I am guilty by reason of insanity, and they did something much more harmless. Maybe it was they tried to rob a bank, it didn't hurt anybody, not that that's harmless, but a violent crime or violent plans going into this. This is going to be a tough sell for the defense to make.
I tend to agree with you, but I'm really sort of sitting on the edge of my seat to see how the jury comes down in this case, because I can see it going one of a couple of different ways. We're going to go to the courtroom, though, in the Loya case, because the judge is back on the bench. Let's listen in.
think we're gonna send the exhibits back down.
All right. I have had the clerk mark for identification an item M. It is a communication from one of the members of the media regarding an incident that happened apparently when I was at the sidebar at the conclusion of my charge, speaking with counsel. I've also received a communication from the jurors that they intend to deliberate until 5 p.m. today. That's been marked N for identification. I have attended a lobby conference where I viewed, courtesy of Mr. Barrows, a film clip that appears to be a clip from the live stream media service. I believe the correct name is LawNewz Network. It appears from the film clip and from the note from the media individual that's marked M, that while I was preoccupied at the sidebar speaking with the attorneys, Mr. Loya turned and faced the jury and mouthed the words guilty and something thereafter to similar effect. Mr. Loya, you have been found competent to stand trial. Certainly, behavior of the sort that I have seen on the film clip is absolutely inappropriate. The court has a concern that it represents an effort on your part to sabotage this trial. I will be exploring what options I think are appropriate in that regard. I am directly ordering you that you are not to communicate with jurors by word or gesture in any fashion whatsoever. You have an absolute right to participate in your trial. It is a public trial. You have a right to participate in every aspect of your trial. By willfully interfering with the proper administration of justice, a defendant can forfeit his or her right to be present during their trial. If there is any repeat conduct on your part, like what I have observed, I will consider removing you from the trial process and having you confined in the lockup, watching further proceedings by video link. Do you understand me, Mr. Loya?
Yes, Your Honor.
Now, I would ask of Mr. Barrows if he would be kind enough to reduce the clip that he showed in the lobby to some type of a disc so it can be preserved as part of the record of this case. Please bring down the jurors.
Yes, Your Honor.
And the alternates.
And the alternates.
I have met with the attorneys We have discussed a course of action. We are in agreement that the jury should cease deliberations, and I should make appropriate inquiry of jurors individually. Is that correct, counsel?
Yes, Your Honor. Yes, Your Honor.
All right. We've agreed on a format for the question that I will put to the jurors. I will do so individually at sidebar. It is not to be filmed or recorded by any media members.
Alternates, Judge.
Thank you.
Okay, folks, we're going to come back on the air because the judge has said that at some point in the very near future, he's going to ask us to stop televising from the courtroom. It turns out that our observation of what the defendant appeared, according to our crew in the courtroom, to have said to the jury, wound up getting the defendant a very, very stern rebuke from the judge in the case. So apparently our broadcast is going to be part of the evidence in this case. The judge asked for it to be preserved as part of the record, and the judge now feels like he has to ask the jury whether they saw it, whether they actually did hear it, and what they think of it. So this is just an astonishing development. Alan, you know, we have to see if the jury heard it, and the judge is going to do that, and he says he doesn't want us to see it. That's fine. That's why we're not showing it. But if they did see it, do they unring the bell, so to speak?
They're not going to forget it, that's for sure, but it's very unusual, and the jury did not appreciate that. Some of them are probably wondering, is this some kind of ploy to convince the jury that he is insane, he's legally insane, he doesn't know right from wrong, he's drifting in and out of reality to some parallel place of existence. But I would imagine if you talk to the jurors after, they'll say, we had a clear idea of this person's mental state. This didn't really change anything because we knew it's incredibly unusual to have something like this happen, but it certainly adds flair to everything that's going on. But I don't think, I'm not going to forget about it, but I don't think it's going to heavily weigh on their decision.
Yeah, I really wonder. You know, he looked at several of the jurors when he said it, so presumably, since he appeared to have been making eye contact, presumably there was eye contact coming back at him. So, you know, look, I do not want to be sitting in the position of making a mess of this trial. It is the defendant who is being rebuked here. It is not me and it is not us. Indeed, they're finding out about this and dealing with it through the proper channels, in essence, because we reported it. That's how it came to the court's attention. You know, they want to keep the broadcast in record, they can keep it in record. So, you know, the last thing I want to do is make a mess of a trial, because I understand all the work and preparation and the rights that go into this. So, but look, I think the judge is right. I think the judge has got to ask the jury at this point, what's going on? Did they see it? Did they hear it? Are they talking about it?
Right. I think what's going to happen is the individual jurors are going to filter that piece of information, what they just heard, they're going to assimilate it with how they're already viewing the case. So say that somebody thinks, yeah, this person's legally insane, then they're going to think this is more evidence of it. If a juror thinks, no, I don't think that he's legally insane, then they'll filter that through that prism. So I don't think it's going to really change, but you're right. The judge is going to want to find out, because just in case, you never know. If the juror's sitting there, what if one says, well, I really thought that he had I didn't think that he was legally insane, but after I heard that, how could he not be? So if something like that influences the jurors' decisions and their thought process, that's something that the judge is going to want to know. And it could affect the outcome. There's all kinds of issues with appeal that this might raise. So it's very irregular, but I can see why the judge wants to nip it in the bud and say, okay, what did you hear of anything, and would you have a reaction to it without talking about the aspect of the case?
Yeah, I think that the judge took that admonition, if I can call it that, to the defendant very seriously and said, hey, look, you've got a right to be here as part of your proceedings, but you can use that or lose that right if you are disruptive. And I think the judge took this as the defendant trying to sabotage his own trial.
Right. Well, he had this overarching plan to kill this woman, Trubnikova, if I pronounce it correctly, who he was obsessed with for so long, and then he wanted to kill himself. So this person is very unstable, to say the least. And so bringing that into the courtroom, yes, the judge didn't want to have any of it, and certainly the judge doesn't want to disrupt this defendant's due process. But from a jury perspective, yes, they probably noticed this, but most evaluations of these types of cases, the jurors go back to the scene of the crime and they evaluate the state of the defendant just before and just after. So I don't think this is going to have a major bearing on it. I think some jurors are going to say, did he do that on purpose, or does he drift in and out of reality? But bottom line is, the jurors know that this person in despair, was suicidal, and had a whole host of issues, but did he know what he was doing was wrong? Is the key question we're supposed to answer, and so that's what we're going to answer.
Boy, I talk about an interesting change in circumstances right up into the end there. Well, let's assume that deliberations are going to continue here once the judge is finished speaking with the jurors. And let's assume that the jurors are going to get to the point where they have to try to figure out what's going on with these four competing experts, because this is the real crux of why I wanted to talk to you today, Alan. I can't picture another case that I've heard of, at least recently, where there have been four psychological experts called to the stand and they only marginally agree with one another about a diagnosis.
Right, and that's what jurors are asked to do all the time about witnesses, but like you point out, this is very unusual with four of these expert witnesses coming in, and what did jurors do with that? Did they decide, okay, well, there's some small differences here, I'm going to work through it, or do they say, okay, I'm just going to pick one that I like? Usually it comes down to professional standards, credibility, and who speaks common sense. You have a lot of witnesses sometimes come on there and they don't know jury speak. They talk over jurors' heads. They use sort of idiosyncratic terms. What witness spoke to the juror, individual jurors? Those are usually the ones that they end up embracing in terms of the content of the testimony. And I think one or two of these witnesses probably emerge as that special witness rings true to the jurors.
So, just to break apart what you said a little bit further, of course we know that jurors are asked to weigh facts all of the time. Did this happen or did that happen? If one witness said the light was red and one witness said the light was green, so to speak, then the jury might have to weigh out what actually happened based on viewpoint, whether the sun was getting in somebody's eyes, whether somebody couldn't see it that clearly, whether somebody was colorblind. I don't know. I mean, facts are one thing, but weighing expert testimony is really rare. I mean, every once in a while you get, a prosecution expert and then a defense expert on one issue, but I can't think of a case where there are four experts and therefore, and look, they did overlap in a couple of little threads here and there, but for the most part, they were giving four different diagnoses of this individual.
Right, and that's going to be the tough thing to untangle. It's very rare to have this type of dynamic. So what's going to happen is the jurors are going to start to deliberate, and that's certainly going to come up because their testimony of these witnesses is pivotal. So you might have one juror starting out saying, "Well, I really liked the first one I heard from. I did not like the third one at all," and then others weigh in. So then it just becomes about the jury dynamic. You might have the experts, you might have others that discredit that same one, and then it just becomes, all right, what is the consensus of the jury? Which one did we like? Which one did we trust? Which one did we think spoke to us in plain English? And once they decide who they go with, that's going to translate into what type of verdict they run. And it could take a long time to do this, to unpack everything. They've heard a lot of testimony is confusing. So go back over the recollections. They're going to talk to each other. They're going to help each other out if there are any gaps in memory. But there's a lot there. And in the end, they have to decide, all right, what are we like? What do we really, what really happened and what's going on inside this guy's head?
I'm I really don't know what to think about this case anymore. Does he have a mental disease or defect? It would seem that the preponderance of the evidence, and I know that's not the standard, but it would seem that the preponderance of the evidence is that he did or does. The question is whether that makes him legally responsible. And legal responsibility is a different standard. You can have a mental disease or defect and still be legally responsible. And it ultimately boils down to say, hey, look, if someone has autism or Asperger's but can still recognize right from wrong, then the law still holds the person responsible. That really boils it way down to low gravy. But that's the core of the analysis. Now, in Massachusetts, it's a couple of different, there are a couple of prongs to it in there, but that's what it boils down to. So I want to switch over and talk a little bit about a case we've talked about before, Alan, and that's the Holly Bobo case, because we talked about it a couple of months ago, then it was delayed, and now it's allegedly happening yet again here this coming Monday. And my first issue off the bat with it is you're talking about a case that has attracted national attention, where there are 6 people from a community who have been arrested for various degrees of alleged culpability on this young girl's disappearance and murder. She was a nursing student. She was 20 years old. Her remains were found 2.5 years after the disappearance. So you got a 2011 disappearance. You've got a 2014 discovery of remains. You've got a purported weapon that, from what I understand, doesn't even have really clear links to the defendants, being discovered this year in 2017. So that's 6 years after the disappearance of the victim in this case. And it's a small rural county with a small jury pool on a case that's attracted national attention. So when it comes to jury selection, which is supposed to begin tomorrow, this case is working Saturdays. How do the attorneys on either side try to get to the requisite number of people who haven't formed an opinion about it, or as, and I hate to stereotype, but as oftentimes the cases in close-knit communities, a trust of the police and an immediate loathe for the accused?
It's almost an insurmountable task. Good luck to them doing this. Like you point out, it's such a small venue. People talk, they've been following it. There's been media saturation from the moment that she disappeared, and then of course when the body was found 3 years after that. So it's going to be incredibly difficult, and the judge has to decide whether or not, okay, so have people coming in and they're going to talk first they've heard of it. It's unlikely that you're going to get people that haven't even heard of this, so they might know a little bit about it. So the key question is going to be, what is the depth of knowledge that people have with this case? So if somebody knows a little bit about it, they're going to be probed in voir dire in terms of, okay, you know a little bit about it. Where'd you hear it from? What did you hear? Have you formed an opinion? And I think some people, whether they can be accurate in terms of self-assessing, will say, I don't have an opinion because I know this has gone on a while and it's gone back and forth and I want justice, but I'm not going to, Mr. Adams is guilty. That's somebody that both sides will take a good look at and say, all right, if the person really be open, then use a strike on him or her.
So one thing that's bothered me about this case is and maybe this is just a misperception, but it seems to me that there are a lot of issues wrapped up in the pure pursuit of justice. And it may just be that the police, the investigators, feel an incredible amount of pressure. You've got 6 people who seem, at least at accusation level, to have surrounded this disappearance, and then, according to the accusation, again, it's just an accusation, but then surrounding the death, okay? And you got immunity flying all over the place. They're trying to use 5 of the others ultimately to somehow get at the one that apparently they think is most responsible, but then you have to back up and question, well, is that person just a scapegoat, or is defendant Zach Adams just the was he actually involved, or are the others just piling onto him? And a lot of evidence that's a whole lot of nothing, or a whole lot of very little, I should say. A gun found that many years later that's rusty. They can't test it. They can't test the ballistics. They got no DNA on it. They got no blood. Okay, I don't know exactly where it was found. Maybe it was found right near her remains. I don't know. But if it wasn't, then what's the connection and what can they prove? So I'm sensing burden of proof issues here attached to this as well. You've got the defense asking the judge to recuse himself because at one point the judge apparently said that the rest of the defendants should be seeking pleas, and that this defendant should be seeking a plea. And well, the last I read, the constitutional guarantee of an unbiased magistrate was still in effect. You've got possible Brady violations being alleged because there's a potential alternate suspect out there that the defense wanted investigated. And the defense is accusing the investigators of failing to turn over a recording of that person. So at this point, I have to feel bad for the attorney who's trying to defend the client who's supposed to be going to trial on Monday, because she's asked for all of these things that she has a right to expect. And it seems from what the local press is reporting that she's not getting anywhere with it.
Right. It seems like the judge thoroughly rebuffed any request along those lines. And it's been a very strenuous investigation. I think a lot of people, and this is something the defense is going to consider, both sides have to think about it when they try to pick a jury, but there's been friction with the DA's office, with some of the investigators, with the Tennessee Bureau of Investigation. So some of the jurors are probably wondering, what's taking so long? What's going on here? Why are we 6 years out and there's no resolution? So the flip side of that is people want resolution. This is a community where this young woman, Ms. Bobo, was horribly, brutally kidnapped, raped, and murdered. And so information is part of jurors who show up for jury duty to know a little bit about it. They're going to want justice served. And there's a mentality of some people that if you're charged and accused of a crime, you probably did it. So that's something that has to think about reflection. But on the flip side of that, all these flip sides here, the defense, jurors know that people cut deals. Even though you have people now pointing the finger at Zach Adams, jurors understand that somebody might have cut a deal, and that weighs in on their assessments of that witness's credibility.
So I know that I asked you this when we were planning to go into this trial the first time, but if you were advising the prosecution on what would be the model juror for their side of the case, what would you tell them?
I would say you want somebody that has an authoritarian bent, and that's somebody who can connect the dots and not be too concerned that there's no real DNA evidence that links this murder back up with Mr. Adams. That's going to probably be what the defense argues. I want to hope there's one juror along those lines. But
hey, Alan, I've got to stop you real quick. I'm sorry, but we're getting some action back in the Loya courtroom in Barnstable, Massachusetts. The judge was just questioning jurors individually in chambers. They're going back into open session, so we want to listen right straight in.
okay.
So we just watched the defendant being led back into court for I don't know how many times here today. That defendant, Adrian Loya, a former Coast Guard member, facing what on the original indictment was 30 separate charges. There have been a few lesser charges added in case the jury can't reach that top murder charge. He was just severely rebuked by the judge for what our crew in the courtroom heard very clearly, in which we reported as the defendant sending a message, it appeared, to the jury. It appeared from what I'm being told, based on our crew in the courtroom, that he looked at individual jurors and said the word guilty several times over again while looking at several of those jurors in the eye. It looked like the judge was getting ready to go on the record, but it looks like he stood back up from the bench yet again. So I'm curious to see exactly where they're going to go now. The judge ultimately did say that the jury would be able to deliberate, or that the jury wished to deliberate, until about 5 o'clock today. And if they couldn't reach a verdict, that they would be pushing off the deliberations until next week. So that's where things stand in the Loya case. As soon as the judge comes back on the bench, we'll go back into the courtroom. But it looks like this is going to take a little bit longer than we thought it was to get going in court. So let's bring Alan back into the conversation. The jurors were just questioned in chambers, probably about an hour and a bit into the deliberations, if I'm timing this properly, about whether they heard this defendant say guilty while making eye contact with them, or at least attempting to make eye contact with them. So a little bit of an interrogation for the jury. If I were a juror, and I wasn't used to the proceedings of court, I'd be a little bit nervous.
Yeah, it's certainly irregular. Jurors usually appreciate the judge reaching out to them, so they know that was a regular and very unusual thing. So smart to do it one at a time, to talk to each juror, so there's no overlapping influence or any of that. So that was, I think, a good move by the judge, and I think the jury probably appreciated it. They didn't like that there was this outburst, and whatever they did with it, I'm glad that the judge reached out to them just to check in with them and basically said, okay, you can. See what happened with what he heard.
Do you suspect that the judge asked them about this, but then told them not to consider it, not to talk about it, not to bring it up in the deliberations? Because in theory, not in theory, in fact, it's not evidence. It wasn't said on the witness stand.
Yeah, I think that's exactly what he said. He probably said, all right, he wanted to gauge whether or not the individual juror heard it, and if so, what did they hear? And then basically, okay, can you just strike that from your memory? Knowing full well, the juror's not going to strike it from their memory, but the judge will say, don't bring it up in deliberations. And if a fellow juror brings that up in deliberations, tell that juror that you're not supposed to talk about that. That's not evidence. On and talk about what you were talking about right before that, or go on to something else. And jurors listen. When you have enough people in a jury deliberating, usually the right side, the right-minded individuals will prevail. So it's not. I don't think you're going to have people talking about this in deliberation.
Yeah, I'm hoping that the jury can just get on with things and continue deliberating and put it out of their mind at this point, because I think that would be in the best interest of justice. So let's hope that that is what happens now. We're waiting for them to come back into open session, and while we wait for that, let's go back to the question I asked you a couple minutes ago, Alan, and if they come back into open session, I'll probably have to interrupt you again, but we're talking about the Bobo case. If you were advising the prosecution, I know you were starting that answer, what would you be telling them to look for in a model juror, given what we know of the case, given what we know about how long the investigation has dragged out, given what we know about the circumstantial nature of the evidence, given what we know about the witnesses with offers of immunity?
Right. The prosecution, I would say, should look for resolution-minded, but he was going to go in and not feel comfortable walking away without finding someone responsible. There's certain authoritarian types, authoritarian jurors who will defer to the prosecution and believe that when somebody's charged and brought to trial, where there's smoke, there's fire. Mr. Adams probably did it. Otherwise, they wouldn't have spent all this time. Actually, that type of juror, the time frame works to that benefit, because they'll think, okay, they didn't rush to judgment. They actually looked at the evidence, took the leads that came into them, and then decided to charge Mr. Adams and work with some of the other individuals who are involved, or maybe not as involved, and they're building up a case against them. That's the kind of juror that'll connect the dots and not worry that there isn't any of this lack of DNA evidence that links Mr. Adams up with the murder weapon and the murder of his Bobo.
Yeah, so we're hearing that it appears that the judge is moving forward, actually, with that process of questioning the jurors, so they're not coming in to open session anytime in the immediate future. So we'll continue on with our discussion of the Holly Bobo case. If you were sitting in the defense counsel chair advising the defense counsel, Alan, what's your best advice to them?
They want somebody who wants that smoking gun. And they want somebody who, and it almost applies literally in this case, they want somebody who's going to say, okay, there's no DNA evidence, and that's what I expect, and they're going to hold the prosecution to their burden. Sometimes you have people who shift the burden, and they expect, and these are jurors who are good for the prosecution, they want the defense to prove they're innocent, But a good defense juror is somebody who will be a little mistrusting of authoritarian types, will be a little skeptical of how this investigation unfolds, and somebody who's going to hold this higher in the civil case, this criminal burden of proof, beyond a reasonable doubt, and they're going to take it seriously. They're going to describe. They're going to hold close to them this notion that you're innocent until proven guilty, and not the other way around. So those jurors are not necessarily going to connect the dots until those dots are very clearly shown that they need to be connected.
So one thing that we do know of the witnesses on the witness list thus far is we have a lot of expert witnesses here, because with circumstantial cases, that's where they hinge. We don't have eyewitnesses, or if we do, they're planning to plead the fifth. And I know I'm piling assumptions on top of inferences there, but we've got people who are experts in remains. We have people who are experts in firearms. We've got people who are experts in cell phones. We've got a handwriting analyst. The prosecutors have sought to display the victim's bones themselves to the jury and claimed that would not be overly inflammatory. So, you know, we've got experts trying to analyze bones, and then we're supposed to have, if the prosecution gets its way, the bones themselves. Do we frequently see that?
That's pretty unusual, and I think that there's a risk of overdoing it with the prosecution. I don't understand that they have to have their witness talk about what they get from that, what they look at the phones. But I've talked to a lot of jurors. This is, of course, an unusual case, but a lot of times jurors get the point quicker than the experts and the juries think they get the point. So showing phones like that, showing anything that's too emotional or graphic in nature might backfire, and the jurors might wonder, why are you doing this? If you really have a strong case, tell us what happened. Oh,
yeah, what do we make of some of the other witnesses here? You know, dealing with this many experts. It just seems to me that it's run of the mill for what we see, but if that's all they've got to go on, is it make it harder from a legal certainty to say this is a conviction beyond a reasonable doubt?
Yeah, that's a tough question, and it just depends on how jurors weigh the competing experts or the cross-examination of one expert. A lot of times, jurors say that the experts canceled each other out, so unless one really stands out, if somebody's really dynamic, if somebody has a good presentation style, if somebody's like they're genuine, they're not a hired expert. A lot of jurors say they don't use hired guns unless both sides have hired guns. So they're going to have to sort through it. They're going to have to experts what they have to say, and then at the end, decide, okay, well, I like this expert. That happened, and so I believe him or her.
Yeah, Alan, why don't you stay on the line with us here, because I might want to pick up some of our discussions here in a bit. I want to go switch back over to the Loya case in Barnstable, Massachusetts, because the judge is in the process of continuing to speak with the individual jurors to see if they heard things, if it's going to bother them, if it's going to color their perception of the case. Apparently, the general consensus thus far, and he's early in the process, is that jurors are saying, yes, they can put it aside. So that's what we're hearing out of court right now, but I want to dip in and continue to listen to some of the prosecutor's closing arguments in the Loya case. I think the prosecutor did as good a job as he could in trying to stitch together the issues with the various experts who didn't seem to agree on very much. But the prosecutor said, hey, look, you know, he made all these plans. He could understand plans. He could follow plans. He could conform his conduct to something. And in other cases, he had no problem conforming his conduct to the law. So he should have been able to in this particular instance. I think the prosecutor did a good job of that in the Loya case. It's a question now as to whether the jury believes it. But let's continue listening to the prosecutor's closing arguments.
He writes, lawyer, prepare yourself for service. Summer 2014. I started thinking of throwing the whole easel plan out the window and thought about just playing the game of life once more. Fuck that idea, and because I know how overboard medical gets, and I don't need more problems. So I continued on with the plan. I have not had second thoughts since. So he chose what in his mind would be more comfortable for him. It's going to be worse for me if I don't kill him. And so he decides. Now, deliberate premeditation does not have to take a long time. It doesn't have to be a long and drawn-out process. It can be as quick as it takes the mind to decide to pull a trigger of a gun or punch the blade of a knife into the body of another person. That could take place in the span of a second, or even less than a second, as long as there is some reflection. And the decision to act on that reflection is followed by the action. This is not a case where Adrian Loya found himself in a situation where there was no time to reflect, where he acted immediately and without thinking. The old story goes of somebody coming home, finding their loved one in bed with another person, and without thinking, they attack that other person, without premeditation. Here we have Adrian Loya saying he'd been planning this Operation Purple Rebel with years of premeditation. He had a reconnaissance mission in October 2014. Don't forget the lengths he went to find out where Lisa was living. Now, the second theory of murder the Commonwealth is proceeding on is extreme atrocity or cruelty. With respect to extreme atrocity or cruelty, the first element, the Commonwealth has to prove to you beyond a reasonable doubt. It's the same as for deliberate premeditation. Adrian Loya caused the death. We've already talked about it. No question is he caused the death. The second element the Commonwealth must prove beyond a reasonable doubt is any one of the following: that Adrian Loya intended to kill Lisa Tuerkheimer, or intended to cause grievous bodily harm to Lisa Tuerkheimer, or intended to do an act which, in the circumstances known to Adrian Loya, a reasonable person would have known created a plain and strong likelihood that death would result. Now, as to the first option, and remember the Commonwealth is one of those three, as suggested the Commonwealth has proven all three, that Adrian Loya intended to kill Lisa Tuerkheimer. It's the same as with the deliberate premeditation. And again, as suggested, it's uncontroverted that Adrian Loya shot 15 times, 11 of those bullets hitting Lisa Tuerkheimer. That he intended grievous bodily harm. He shot her 15 times, and 11 of them hit her in the chest, another in the chest, in the right thigh, in the left thigh, in the left hip, in the right chest, in the left thigh, in the right leg again, in the abdomen, and in the back. And third, that Adrian Loya intended to do an act, namely repeatedly shoot Lisa Tuerkheimer in the circumstances known to Adrian Loya. A reasonable person would have known created a plain and strong likelihood that death would result. Again, 11 shots to the various portions of Lisa's body, when he shot 15 times into the mattress. Circumstances known to Mr. Loya obviously would create a plain and strong likelihood that death would result. It's what he intended. Now, the final element is that the killing was committed with extreme atrocity or cruelty. But there are some factors, I suggest, that you may consider in determining if this was a killing with extreme atrocity or cruelty. The Commonwealth, I suggest, only has to prove one of these factors. But I suggest we have proven many factors. Whether Adrian Loya was indifferent or took pleasure in the suffering of Lisa Tuerkheimer, the consciousness and degree of suffering of Lisa Tuerkheimer, the extent of the injuries to Lisa Tuerkheimer, the number of blows delivered, the manner, degree, and severity of the force used, the nature of the weapon, instrument, or method used, and or the disproportion between the means needed to cause death and those actually employed. Now, the Commonwealth has to prove one of those seven, but I suggest to you the Commonwealth has proven all of those seven in this case. Let's look at those factors individually. One, indifference or pleasure in the suffering of the victim. Shot her 11 times. Wants to tease her and terrorize her. Wants to have her here as the last thing before she dies. I'm here because of what you did to me. Imagine the terror as somebody breaks into their room and is holding a gun at them. Specifically Lisa, who thought that this was not an event that she needed to worry about ever again. She apologized the day after it happened. She apologized repeatedly. She didn't even remember because she was drunk what had happened. And then here's Adrian Loya out of nowhere with his gun and rifle. Consciousness and degree of suffering of Lisa Tuerkheimer. Listen to the 911 tape, Exhibit 119, because at the beginning of that 911 tape, I suggest to you, you can hear Lisa dying. Anna tells how she had the chance to kiss her or Lisa Tuerkheimer just as her life ended. You listen to this, you can hear Lisa's last words at the beginning of this DVD. The extent of the injuries, well, 11 separate wounds. The number of blows inflicted, again, 11 separate gunshot wounds. The manner and degree and severity of the force used. Now, Mr. Loya's first statement to the police, and it's horrible how I took out Lisa, you know? In his second statement to the police, this viciousness, not so much, at this. Lisa was the only target. And finally, the disproportion between the means needed to cause death and those employed. Dr. Zane told you one of those shots could have been fatal, and the death would have been sudden. But Adrian Loya administered 11 gunshot wounds and 15 shots total into that mattress. Now, I'm suggesting the Commonwealth has proved beyond reasonable doubt that Adrian Loya committed first-degree murder on both of the deliberate premeditation and extreme atrocity. But let's look a little more closely at the claim of lack of criminal responsibility. The Commonwealth certainly bears the burden of proving that Adrian Loya was criminally responsible at the time of this crime beyond a reasonable doubt. And I suggest the evidence here certainly does that. Ladies and gentlemen, focus on the evidence. No one is asking you to substitute any sympathy for Lisa Tuerkheimer, Anna Tuerkheimer, or Jared McDonald. You look at the evidence, apply that evidence to this case, leave sympathy completely out of it. No one wants you to be that sympathy overwhelming here at all. Adrian Loya may have been depressed, but he wasn't so depressed that he didn't have an understanding of what he was doing, that he was incapable of making decisions and choices, in understanding the consequences of those decisions. Did Adrian Loya suffer from mental disease of defect? I think, of course he did. All the doctors told you that he did. So the question isn't just because you suffer from a mental disease of defect that you're not responsible. It's, does that disease or mental defect cause you to not be able to appreciate the wrongfulness, substantially appreciate the wrongfulness of your act or substantially conforming conduct to the requirements of the law? Because you could be suffering, I suggest to you, a mental disease of defect and still be able to do those things, just like he did. Dr. Kelly tells you he didn't, Mr. Loya, didn't have a crush on Lisa Tuerkheimer. Is that even remotely believable, ladies and gentlemen? Jacob Heller tells you he thought there was something going on up there. Anna Tuerkheimer tells you she thought there was something up there. Even Adrian Loya in his writings and statements tells you, again, from Loya Wars, Exhibit 128, White Jetted Down, October 2011, it was during this time I started to get those good feelings that you get when you want to be more than friends. Surprise! Late October 2011. The tiny but present romantic thoughts at the time I classified as normal instinctual reactions in a hetero male for female. Meet the Newlyweds, late January 2012. Lisa then turned towards me to put her head on my shoulder and got right in next to my ear to whisper, asking if I wanted to leave. Something with her voice, breath, and touch gave me those immediate good flashbacks to better bar hopping nights in my early days in the Coast Guard. And then there was the small, sweet connection with Lisa that sparked in me by her doing this. The first WTF moment, February 2012, Packages. Watch the movie which was Sherlock Holmes' Game of Shadows. In it was Naomi Rapace, playing some gypsy, but all I saw on the screen was Lisa's face. This would be the first time that I'd see a woman with black hair and eyeliner and immediately associated with Lisa. The bad night, September 9th, 2012. The feeling was amazing. It was 1:30 a.m. on Sunday, and I felt so alive as I got ready and left to Lisa's house. It was the feeling of being wanted by somebody, that there was a person out there who wanted me to be with them, somebody who wanted my company. Lisa Berlanga wanted Adrian Loya with her to have some late night fun. I was the happiest I had ever been in my entire life because somebody wanted me in their life, and it was a person I also wanted in my life. It was the face of someone who had missed me and was truly happy to see me again. Seeing that face gave me the best tingle throughout my body, and I was so happy to see her as well. Not knowing how to deal, October 2012. How would I still gone over to her house if I knew what the outcome would be? I hesitated, but I went with my gut nature, which was yes. Yes, I still would have gone. Those initial feelings I had before I walked into her house were amazing. And if I could do it again, it would be for that hope I had as I went there that everything was going to be all right with me and Lisa, if not better. The Siren Song, November 23rd, 2012, with her saying that so softly, her butt pressing into my shoulder and her head caressing the back of my head as she kept me in place. I just kind of became at ease and stayed in the position no matter how my knees started feeling because the tingles she gave me made me feel amazing. I became intoxicated by the smell. She continued being very close to me and gently touching me, which she had never done before. The very friendly yet flirty attitude she had this evening with me made me feel great, even if it was another case of sexual assault done by her. I was ready.
We're going to break out of that clip for a couple of minutes. Alan Tuerkheimer, jury consultant out of Chicago, is still here with us. The judge is still questioning the jurors individually in the courtroom. We were asked not to show it or broadcast any audio, but here's what we understand is being said. Our crew heard the defendant say guilty 3 times as he was looking at various jurors as the attorneys were going up for a conference or at some similar point. Apparently, one juror thought he or she heard the defendant say, "Not guilty, help me." Another, and that juror apparently heard that from another juror, so they were already talking about it. Another juror thought he or she heard "not guilty." Yet another juror said he or she heard the defendant say something but quickly turned away because it was unnerving. That's where we stand right now with what we know. So it sounds like there's a couple different versions of this starting to float around. Our crew thought that they heard guilty, guilty, guilty. But apparently there are other things being heard by other people who maybe were a little bit closer, because I think the jury was a little bit closer to the defendant than our crew was. So, Alan, first of all, we've got different perceptions, and then second of all, what do we make of it?
Right. This is why witnesses are mic'd up, why attorneys are mic'd up, and they have certain logistics set up in courtrooms for the jurors to hear what the witnesses and the lawyers have to say. So it is interesting, and it just goes to show that if something like that happens, you'll get different interpretations, different meaning attached to it. And apparently the jurors seems like they heard it. They might have heard that he said not guilty. Somebody said they heard something else. So I don't think it's going to factor into their decision making. I think they're going to get past it. They're not going to be able to forget it. So when the judge says to them, "Can you put it past you, put it out of your mind?" I think they can do that. But it is interesting that something like that happened. It's highly unusual, as we talked about, and it's just interesting to see how this plays out. Like I said, I don't think it's going to have an impact on the deliberations, but it just adds some color to what has been kind of an up and down circus of a trial with so many things that have been unpredictable.
All right, and we're just getting another piece of this puzzle here as well. Apparently one juror is saying that he or she didn't hear anything, but that the other jurors were talking about it, presumably right away, because they were only back there for a little while before the judge got wind of it through us, it turns out. and started digging into things. So this apparently did make an impression on people, and there was a communication. You know, for communication, you can't just say something into an open room. It has to be sent and received. Well, something was sent and it was received by at least a number of people on that jury.
Right, it's like the game of telephone in a different jury dynamic. But what happens a lot in deliberations, and we're so immersed in a case, lawyers are so immersed in a case, they're so committed to it, they know what's right, they know what's wrong, they know what they're supposed to look at on one hand, they know what's impermissible on the other. Jurors are lay people. Yes, I'm sure they're going to follow the instruction, but they've been listening to all this evidence, they've been hearing witnesses for so long and have not been able to say anything about it. That's what happens in a trial. So finally they get to deliberate, and they're not necessarily going to go right into the verdict questions. It's cathartic. They have all this information. They haven't been able to talk to anybody about it. So usually jurors start to unleash a little bit and give their reflections on the case. They usually say what they like, what they didn't like, how they're leaning, what they feel. And certainly since this happened way at the end of the day or just before deliberation, it's fresh on their minds. They're kind of somewhat amused by it maybe, or they think that it's highly irregular. And so I'm not surprised that that's something they talked about. But I'm sure that after they were told not to talk about it, move on, they're not going to be talking about it. It's just one of those things where when a jury starts to deliberate, start to get to know one another, it's almost like you're in a social setting, you're a stranger for a long time. Some new subject matter that you're required to discuss, which you were required not to discuss proceeding. So they chat a little bit. It's informal, and so this is certainly something that they wanted to talk about because they were surprised by it and didn't expect the defendant to turn around and say whatever some of the jurors thought that he said.
Yeah, Alan, normally we sign off at about 5 o'clock, and I suspect that it being a Friday evening, there's other things you'd rather do than talk about juries with us. So I think we'll let you go, but just a note to those watching, we're going to stay on the air as long as court's in session in the Loya case here. We can't show you this questioning between the judge and the jurors, but we can report on it if we get a couple of tidbits. So we'll be on the air to continue to sort through this thing. But Alan, it was good to talk to you again. A lot of issues confronting juries here. You're the unique man to talk about it. So we appreciate you joining us yet again.
Thanks, Aaron. Great coverage. I appreciate it.
All right. Have a good weekend.
You too.
Okay. As I said, we're going to stay on